Welcome to this explainer. Today, we're taking the incredibly dense and, let's be honest, pretty unforgiving rules of the Florida appellate system and translating them into a clear, straightforward roadmap for anyone considering representing themselves. Whether you're doing this by choice or out of financial necessity, you're going to quickly realize the appellate courts operate on a completely different level than a standard trial courtroom. So we're unpacking the Pro Se Appellate Handbook right here, right now, to show you exactly what it takes to navigate this legal labyrinth. Let's get into it. Alright, here is our roadmap for today. We'll be looking at 1. The reality of going pro se, 2. Beating the clock, 3. Assembling the record, 4. Navigating appellate motions, 5. Writing the perfect brief, and finally, number 6. The financial stakes. Okay, let's kick things off with section 1. The reality of pro se. So we need to start by shattering a pretty massive myth right out of the gate. Stepping into the courtroom without an attorney, it means you are held to the exact same standards as a seasoned legal professional. Literally, ignorance of the law or procedural rules is absolutely never an excuse. You are fully responsible for reading, understanding, and strictly following the Florida Rules of Appellate Procedure. If you file something wrong, or even just format it incorrectly, the court will penalize you exactly as they would a practicing attorney. There's no special treatment here just because you aren't a lawyer. And honestly, this brings us to one of the biggest misconceptions in the entire legal system. An appeal is not a do-over, right? Trial courts are where you bring your witnesses, you present physical evidence, and you argue the actual facts of what happened. But the appellate court, that is a strict review limited entirely to the existing record. The judges there aren't going to hear your story again or try to weigh who is telling the truth. Instead, they're hunting for specific legal errors made by the lower tribunal. It's really just a highly technical search for procedural mistakes in what has already happened. Moving right along to section 2, beating the clock. Now, in the legal system, the clock is absolutely your biggest adversary. Missing that initial 30-day deadline to file your notice of appeal, it's fatal to your case. This is what's known as a jurisdictional deadline. If you file on day 31, your right to appeal is permanently waived, and the appellate court literally lacks the legal power or jurisdiction to even hear your case. So beating the clock is step 1 for sure. And from there, the timeline just continues its rigid march. You've got 50 days for the clerk's record index and exactly 70 days until your massive initial brief is due. Which brings us to section 3, assembling the record. So now that the clock is officially ticking, you've got to build your case using what we'll call the time capsule approach. Because the appellate court only looks at what already happened, you have to formally package up that past history and send it up to them. If a document, a piece of evidence, or a hearing transcript wasn't placed in the trial's time capsule before the final judgment, there is no way you can open it and add new evidence during the appeal. The appellate court's universe is restricted to the 4 corners of the specific record. If it isn't in there, it simply doesn't exist for the purposes of your appeal. Now, what's really surprising about all of this is that the burden of actually assembling the record and ordering those transcripts falls completely on you, the appellant. The trial clerk doesn't just automatically pack up every piece of paper and send it up. No, you have to file directions to the clerk within 10 days. If you had a hearing, you must formally designate the court reporter to transcribe it, and you're the one paying them an estimated cost, usually about half up front. Basically, you have to drive this entire process yourself. And the handbook makes it incredibly clear. Failing to properly instruct the clerk or court reporter means the appellate judges will literally have nothing to review. And without a record, the appellate court generally just presumes the trial judge was right. It's called the presumption of correctness. So if you fail to provide the transcripts that show the judge making an error, yeah, your appeal is almost certainly going to be dismissed or denied. Okay, let's jump into section 4, navigating appellate motions. While your record is being assembled, you might find yourself needing to ask the court to take some specific actions through formal motions. But motion practice on appeal is very different from a trial court. There are way fewer motions, and they almost never involve in-person hearings. Most motions, like asking for an extension of time to file your brief, will toll, which basically means pause your deadlines until the court rules. But you've got to be careful here. Motions to stay a lower court's ruling, like trying to stop someone from collecting a money judgment against you while you appeal, well, those usually require you to post a significant monetary bond. Often, that bond has to equal the entire judgment amount plus twice the statutory interest rate. Crazy, right? Let's turn our attention to Section 5, writing the perfect brief. Because appellate courts rarely grant oral arguments for pro se litigants, your written brief is really your one and only chance to persuade the judges. It is quite literally your entire case on paper. And let me tell you, the formatting rules are absurdly rigid. Your statement of the case and facts cannot contain any arguments, none, just facts, with specific citations to the exact page numbers in the record. And the physical presentation, oh, it's equally strict. If you're filing on paper, no glossy pages, no staples, only paper clips or rubber bands are allowed. Even your font choice is strictly limited to Arial or Bookman Old Style. You literally have to include a certificate of font compliance at the very end of your brief just to prove you followed the font rule. But the ultimate challenge here is space. You have exactly 13,000 words to make your entire argument in that initial brief. That usually comes out to about 50 pages. And the courts, they will generally just reject anything that goes over that limit. So you have to be concise, you have to be highly organized, and you have to meticulously cite past case law to prove exactly how the trial judge applied the law incorrectly. It's a massive undertaking. Finally, we've arrived at Section 6, the financial stakes. You know, a lot of people just assume representing themselves saves money, but let's break down some of the hidden traps here. First off, as a pro se litigant, you can never recover attorney's fees for the hundreds of hours you spend researching and writing. Why? Because you aren't a licensed lawyer. However, if there's a contract or a statute that actually allows for attorney's fees and you lose your appeal against a party who does have a lawyer, the court might force you to pay their attorney's fees. And on top of that, the losing party generally has to pay the winner's court costs, which includes those hefty bills for filing fees and court reporter transcripts. So the financial risk is very real. So, knowing the incredibly strict formatting rules, that unforgiving ticking clock, and the frankly devastating financial risk of potentially having to pay the other side's legal bills, you really have to seriously weigh your options. The appellate court offers absolutely no safety net. So before you go and file that notice of appeal, you have to ask yourself a tough question. Are you truly prepared to walk this tightrope completely alone?